Warning, Bill C12 lets Canada cancel everything, even your status. Welcome back to Canada Chronicles. Canada's immigration system is facing one of its biggest shakeups yet, and the changes could affect everyone, from temporary workers and students to permanent residents who thought their status was secure. A powerful new law known as Bill C12 would give Ottawa the authority to suspend or even cancel immigration documents in the name of public interest. That means entire groups of applications, work permits, or even permanent resident cards could be wiped out with a single order. In this video, we'll break down what's really inside Bill C12, why critics are calling it the most dangerous immigration reform in years, and how it could impact you or someone you know. And stay tuned until the end, because we'll uncover the silent trigger that lets Ottawa cancel your status overnight. A hidden clause most people haven't heard about, but everyone should understand. So make sure to subscribe and turn on notifications so you never miss an update on Canada's fast-changing immigration laws. Let's get started. The growing threat to immigration status. Canada has always portrayed itself as a welcoming country for immigrants, international students, and foreign workers. But beneath that reputation lies a growing crisis. Processing delays are piling up, backlogs are worsening, and policy shifts now threaten not just new applicants, but even those who already have approved status. One of the most alarming developments is Bill C12, introduced in October 2025 under the title An Act Respecting Certain Measures Relating to the Security of Canada's Borders and the Integrity of the Canadian Immigration System. This proposed law would give the federal government sweeping new powers to suspend, cancel, or alter immigration documents, including valid visas, permits, and even permanent resident cards, whenever officials decide it's in the public interest. For thousands who have played by the rules, paid their fees, and waited patiently for approval, the idea that their legal status could be suddenly revoked feels like a betrayal. Yet this is exactly the risk at the center of Bill C12. As housing pressures, labor shortages, and public frustration grow, the government appears ready to shift from managing immigration backlogs to resetting the system altogether. The problem is no longer about waiting for approval. It's about whether your status could be erased entirely, what Bill C12 actually proposes. To understand why this matters, we need to look at what's inside the bill itself. Expanded government powers. One of the most consequential provisions gives the governor and council, which means the federal cabinet, the authority to cancel, suspend, or modify any immigration document or class of documents in the public interest. That means the government could target not just individuals but entire categories of applicants, such as international students, temporary foreign workers, or permanent residents, if it believes doing so would protect the system or serve national priorities. The Canadian Immigration Lawyers Association warns that this goes far beyond anything previously allowed under immigration law. It grants Ottawa sweeping control over immigration decisions that were once handled case by case. Backlogs and administrative pressure. The context behind this bill is equally important. Immigration, Refugees, and Citizenship Canada, the department responsible for processing applications, has been managing more than 2 million files across various programs. Many of those applications have been stuck in processing for months or even years. Bill C12 is being sold as a modernization measure, a tool to combat fraud, fake college admissions, and illegal work permits while reducing administrative overload. But modernization also means something else: more centralized control and less individual oversight. Instead of solving the backlog, this new power could allow the government to erase it simply by canceling large groups of applications at once. Erosion of protections. Critics argue that Bill C12 undermines long-standing principles of fairness. Under current law, an individual has the right to be heard, to appeal, and to receive written notice before any major immigration decision is made. With this bill, that could change. If the government decides a certain program or category of applicants no longer serves the public interest, those rights might not apply. What used to be a system based on rules could become a system based on discretion. Who could be impacted? This isn't a distant or theoretical problem. The potential impact of Bill C12 could reach almost every kind of immigrant or applicant: temporary foreign workers and students. Students and foreign workers often believe they are safe as long as they follow the rules. But if Bill C12 becomes law, an entire class of work or study permits could be suspended overnight. For example, If the government finds a post-secondary institution issuing fraudulent admission letters, it could cancel every permit tied to that school, even for innocent students who met every requirement. Industries such as agriculture, healthcare, construction, and transportation, which depend heavily on temporary foreign workers, could also face disruptions if large numbers of valid permits were suddenly voided. Permanent residents. The most alarming effect may fall on permanent residents. Under current laws, you can lose your PR status only for reasons like criminal convictions, fraud, or failing to meet residency requirements. Bill C12 introduces a new layer of uncertainty. It gives the government the power to suspend or cancel permanent resident cards, even without individual misconduct, if doing so is deemed in the public interest. This could mean sudden travel restrictions, job loss, or barriers to re-entry into Canada. The emotional impact on families who believe their future was secure cannot be overstated. New applicants. For those waiting in long queues for sponsorships, PR applications, or work permits, this bill could change everything. Instead of processing delayed files, the government could erase entire streams to manage capacity. Imagine checking your application portal one morning and finding your file gone. Not refused, not denied, simply deleted from the system. That's the power Bill C12 would legally grant. Thanks for staying with us this far. We appreciate your time and hope you're finding this information valuable. The silent trigger that lets Ottawa cancel your status overnight. Hidden deep within Bill C12 lies a clause that few people have noticed, yet it could affect every immigrant in Canada. It's what we call the silent trigger. This clause gives the government authority to cancel or suspend any document or class of documents, including work permits, study permits, and PR cards, if the minister or cabinet decides it serves the public interest. What could trigger this? The bill lists situations such as widespread fraud, cyber attacks, systemic errors, national emergencies, or even sudden changes in migration trends. Here's what makes it truly dangerous. No individual hearing is required. Once the government declares a certain stream or program as risky, your document could be invalidated simply because it belongs to that class. Imagine being a student whose school loses its government recognition. Overnight, your permit could be suspended. Or imagine being a permanent resident under a program now deemed high risk. Your PR card could be canceled without notice, even if you've done nothing wrong. This isn't about individual guilt or misconduct. It's about bureaucratic power, the ability to reset entire categories of immigration with a single order. Why the government says it's necessary. From Ottawa's perspective, Bill C12 is a solution to serious challenges. The immigration system has been struggling with record-high applications, housing shortages, and concerns about fraudulent schools and employers. Supporters argue that the new powers would allow authorities to act quickly during crises, protect national security, and manage fraudulent activity more efficiently. They also point to growing public frustration over temporary residence and say the government needs more flexibility to respond. But while the logic might sound practical, the risk is that such sweeping authority can be easily abused or poorly applied, punishing legitimate immigrants alongside bad actors. The real consequences. Let's look at what could happen if Bill C12 is enforced aggressively. Sudden loss of legal status. If your permit or PR card is suspended, you may immediately lose the right to live, work, or study in Canada. You could be prevented from traveling or re-entering the country, even if your application was approved months ago. Limited legal recourse. Existing laws provide some avenues for appeal, but Bill C12's language gives the government exceptional discretion. Once a class-wide order is issued, individual challenges may be nearly impossible. The result could be mass cancellations without accountability, social and economic fallout. The industries that depend on immigrants, from hospitals and construction sites to farms and restaurants, could experience labor shortages if large numbers of permits are revoked. Families could be separated, careers disrupted, and trust in Canada's immigration system severely damaged. This is more than a policy shift. It's a transformation of how Canada defines belonging, opportunity, and fairness. What you can do to protect yourself. While Bill C12 is still being debated, awareness is your best defense. Here's what you can do now. Stay informed. Follow all updates from Immigration, Refugees, and Citizenship Canada, and verify that your school or employer maintains compliance with government regulations. Keep your records. Save every document, receipts, letters, and approval notices, and back them up digitally. Maintain your status. Renew permits early, follow all visa conditions, and keep your residency obligations if you're a permanent resident. Plan alternatives. Explore provincial nominee programs or family sponsorships in case one stream is affected. Seek professional help. The Canadian Immigration Lawyers Association and the Migrant Rights Network are among the organizations raising awareness about Bill C12 and offering guidance to affected individuals. Final thought. Your immigration status, whether it's a visa, a work permit, or permanent residency, should be a foundation you can build your life on. But with Bill C12, that foundation could be shaken by a single government decision. Staying informed, documenting everything, and knowing your rights are now more important than ever. What's hidden inside this law could decide your future in Canada, and awareness is your strongest protection. The truth is clear. Bill C12 could completely reshape Canada's immigration system. It's not just another policy update, it's a shift in power that could decide who stays, who goes, and who loses their status overnight. Whether you're a student, a worker, or a permanent resident, understanding what's hidden in this law could mean the difference between security and uncertainty. Stay informed, keep your documents up to date, and never assume your status is safe without knowing what's changing behind the scenes. If you found this breakdown helpful, don't forget to like, subscribe, and turn on notifications so you never miss future updates from Canada Chronicles. See you in the next video.